Hello, everyone. My name is Andrew Nyamayaro, your solicitor from Tanlo Solicitors. And today we are having a question and answer session. So if you've got any questions that you have, just put them in the chat so that I can be able to read them and to hopefully be able to respond to them. It's Andrew from Tanlo Solicitors. I will just wait a few minutes to have more people come in, then I'll start responding to questions and answers. I'll just give a few moments for people to join us, then I'll be able to respond to the questions that I have. Okay, just for your information, today I'm answering questions that you might have, any legal questions, hopefully. The ones which I cannot answer straight away, I will take a note and then I will be able to respond to them at some point, either to the people that have asked the question directly, or I'll do another live session so that I'll be able to respond to those questions. So if you've got any question, just put them in the chat, then I'll be able to respond to that. So the first question that I have, it comes from someone who says that they want to bring over their spouse from abroad. However, in terms of their financial situation, they are on benefits. They do receive PIP and ESA. So, in terms of bringing someone from outside the United Kingdom as a spouse, one of the requirements that a person needs to meet is the financial requirement. And there's different ways in which a person can meet the financial requirements. It can be met by people or the applicant or the sponsor proving that there is sufficient income by way of salaried income or employment. So when someone is employed, or so where someone is self-employed, or they work for themselves, they own a company or they are a director, it can also be proven by way of savings, and these sources of income can also be mixed. And there is a formula or a way that they can that is used by the Home Office to calculate the income. As a general rule, someone needs to be earning at least 18,600 per annum for them to be able to sponsor a spouse or a partner to come from outside the United Kingdom. The other sources of income that might be recognized by the Home Office are pension. If you are a pensioner and your pension meets the requirements, and the benefits, it's only a few benefits that are recognized as a source of income to bring someone over to the United Kingdom. And fortunately for the person who has asked the question, the PIP is recognized. So where someone is on a PIP benefit, then they can be able to sponsor someone to come to the United Kingdom. So it's a matter of proving and showing that you are on the PIP. But however, the person that you want to bring to the United Kingdom should also meet the other requirements of the visa. So that person should meet requirements such as the suitability. They should be a person of a good character. They should not have any criminal convictions or court judgments against them, or where such convictions are there or where court judgments are there, then they will need to make a statement to explain their circumstances. And then you also need to prove that there is a relationship between the sponsor and the person being sponsored. This applies to all the partner routes, such as the fiance visa, the unmarried partner, the spouse visa. So you need to prove all these requirements that I'm mentioning about. Of also importance is the issue of accommodation. You need to show that there will be sufficient accommodation for the person to come and stay whilst they are in the United Kingdom. So you need to consider the accommodation as well. So in a nutshell, that is what someone you have to consider when they want to bring over someone to the United Kingdom. As to the elements of the evidence to be adjusted, that depends on different circumstances for different people. But in a nutshell, you need to prove your income. If you are employed, then if you're employed by the same employer for the past 12 months, you need to produce 6 months pay slips. You need to produce 6 month bank statements, a letter from your employer, and so forth. You can add additional information if you want to. If you are self-employed, it becomes a bit complicated. It depends on what sort of self-employment you have. Self-employed as a director, or you've got your own company, or you are a sole trader and things like that. So the circumstances will also determine the kind of evidence that will need to be submitted. So it's important to read through or to inquire before you make an application, because if you submit a wrong application, then or the wrong evidence, then you risk getting your application refused. Linked to that is another question on how long it takes for the process of bringing over a partner from abroad. Again, this is a question that depends with the country from which the person is coming from. Some countries have got a long backlog, some have got a short backlog. But for the past 12 months, by experience, most applications to bring a partner from outside the country are taking around 6 months for them to be decided. They used to take shorter before the COVID lockdown, and after COVID, they're still taking a bit of time to be decided. And unfortunately, there was a war that broke up again in Ukraine, and resources had been targeting Ukraine more than other entry clearance applications. So that has meant that the delays have continued going on. However, the Home Office has slowly reintroduced the priority or the super priority application. So, where you qualify for, or if in your country the super priority or the priority puts are available, then the decisions will be made quicker. Ordinarily, they'll be made within, say, a month, 4 weeks, or at most 3 months. So, the super priority or the priority will make you jump the queue, and you should be able to have your decision made quicker than a normal applications or standard applications. So again, depending from the country that you are applying from, then the period is give or take 6 months on a standard application. However, we are noticing that the Home Office is now tending to make decisions quicker. We have made applications for um, visa applications from outside the country that have yet made a quicker turnaround than we anticipated, and even some in-country applications as well. If they've made a quicker turnaround period than we anticipated. For those who are spouses on skilled worker visa or dependents on a skilled worker visa, those ones are pretty much quick, give or take 3 weeks a decision should have been made, whether you're the main applicant or you're the dependent. So for the skilled worker visas, the skilled worker dependent visas, it's about 3 weeks for a decision to be made by the Home Office. The other question that I have, and if any of you have got any questions, please put them in the chat section so that I'll be able to respond to those questions through the chat, or at least through this live presentation. If you've got a question, please put it through and then I'll be able to respond to you. The other question that I have is how much are you taxed for your second job? So I think this is a question that is being asked by someone who has recently relocated to the UK on a visa for the skilled worker visa. And it's a question that has been ongoing from so many people. Some people believe that their employers are making too many deductions from their salaries, or are making unlawful deductions from their salaries. And if any deductions are unlawful, you've got a right of claim against your employer. You can even take it, if initially take it through the company. If it's not resolved, take it through to ACAS. And if ACAS does not achieve any conciliation, then you have to go to the tribunal. You must bear in mind that most cases under employment law, most circumstances or issues under employment law should be submitted to the tribunal within 3 months, 3 months less 1 day of the issue or happening, or you leaving your employment. So be it that the employment tribunal has got very strict timelines, it has got very strict deadlines, and when it comes to um, submitting your claims to the employment tribunal or to adhering to directions in the employment tribunal. Back to our question, how much are you supposed to be taxed in a second job? Okay, so this is quite a wide question, but if I am to respond to someone who is on a basic tax rate, if you are on a basic tax rate, that is the 20% tax rate up to the threshold of the tax band, where you are taxed 20%. For your second job, they will tax you using the basic rate, which is commonly known as the BR, and everyone is entitled to a tax-free threshold. So if both your jobs, the main job and the second job, falls within the tax-free threshold, then you are not taxed anything effectively. But if both jobs tax you above the threshold, the tax-free threshold, then you will be taxed 20% up to the threshold of the lower band of tax. Then outside of that, you might be put on the D0, the 40% if you're in the next band, or you might be put in the 45% rate, which is the D1. So if your income is off my head 50,000 and below, you're in the lower band, and therefore your tax rate should be 20%. Even if you have been taxed more than that, the HMRC at some point will have to refund you the excess tax that you paid. If you underpaid your tax, then the HMRC might at some point get in contact with you, demanding you to pay up or top up your tax. So for a second job, you are on a BR most of the time in most circumstances, unless if you're on a D0 or on a D1. Okay. So those are the questions that I had for today. I seem not to have any other questions in the comments. So unless if someone has got any question that they want to quickly type up, then that can bring us to the end of our presentation today. At Tanlaw, we do different aspects of law. We do immigration, employment, wills and probate, business advice, corporate advice, charity advice. So if you've got any issues in those areas of law, then contact us, or even if it's an area of law that we do not deal with, we can send post you to colleagues that we work with within our industry. So that is our presentation for this week. And next week again, we'll have a presentation on something different. Let me just scan through the comments to just see if anyone has got any comments or chats that they've put or any questions, and there is none. So thank you so much for watching. My name is Andrew Nyamayaro from Tanlo Solicitors, and our contact details are on the screen. Please subscribe to our YouTube channel. We've got more than 100 videos that are very helpful, and we have got a group on Telegram where we put tips for tier 2 immigrants that have arrived into the United Kingdom. So we do put tips on different aspects of life in the United Kingdom, not only legal tips, anything to do with how you can settle down. And we draw this from our own experience, having come to the United Kingdom and settling down. So things to do with, for example, the schools for children, how to conduct yourself in the community, British etiquette, insurances, how to get insurances or mobile phone deals, and so forth. We just help people with such information. So you can subscribe to our Telegram group. If you wanted the link, contact me. I'll give you the link and you can join. We put a tip every day that is helpful to the recent arrivals or even people that have been in the United Kingdom for a while. The tips are very useful. Thank you so much.